a saber lo que es un trust, lo que es la garantía para cuando nosotros, esposo o esposa, nos pase algo, podamos estar protegidos. La mayoría de los que están aquí escucharon la palabra trust cuando yo comencé a decirlo. Otros lo hemos pensado muy a menudo, pero nunca lo hacemos. Y otros no encontramos un abogado que sea especialista en trust, porque ni los abogados de nosotros se imaginan dónde conseguir un abogado de trust. Y cuando está enfermo el paciente, el esposo o la esposa, ahí viene el corredero. ¿Qué hacemos? Y ahí nos sale muy costoso. Julio Pérez es responsable de que yo hoy llamase a esta reunión. Y tuve que llamar al abogado Soto, Fran Soto, de la Asociación de Golf Dominicana, para que consiguiera un abogado que sepa de trust. Porque son pocos, vuelvo y les repito, abogados que se dediquen a trust. Esta joven es dedicada solamente en eso. Era socia en una compañía y se fue ella independiente para trabajar solo lo que es la palabra trust. Ella habla inglés, lo que habla en español nada más, utilizaremos una explicación al final con ella, pero la mayoría pongan el oído sólido en inglés. En mi caso, yo le voy a decir, y muchos de ustedes saben que yo me he dedicado a la vejez, a ayudar gente mayores de edad a retirarse. Porque una de las únicas cosas que nadie nos enseña es a retirarnos. Nos enseñan a la escuela, nos enseñan de todo, pero no al retiro. Y cuando llegamos a la edad de retiro andamos locos, turulecos, porque no sabemos absolutamente nada. Muchos dejan de recibir mucho dinero porque se retiraron sin saber lo que estaban haciendo. Tienen seguro pagando $500 mensuales y quizás no tienen que pagar nada. A mí me toca ayudar a esos envejecientes. Me he dedicado a eso. Es como que mi vejez me llegó para ayudar gente en la vejez. Quiero decirles que muchos de ustedes no sacan un seguro de vida y cuando vienen a saber del seguro de vida ya tenían el cáncer y por ende ya nadie lo puede asegurar. A veces ni siquiera sacan el seguro de enterrarlo, porque ya pasaron y también están enfermos y ni seguro el seguro de enterrarlo podemos conseguirlo. Simplemente porque no hicimos lo que teníamos que hacer a tiempo. Y le estoy hablando que el 90% de los latinos nos pasa eso. Venimos a sacar el seguro de vida, venimos a sacar el seguro de salud ya cuando estamos enfermos y por ende ya no podemos conseguirlo. Lo mismo pasa con el trust. Entonces mucha gente no entiende que lo que usted aprende tiene que enseñarlo. Y lo que usted está viviendo a diario tiene que enseñarlo. Porque si usted se queda con lo que usted aprendió solo, usted no hizo nada en su vida. Y se va a ir para el otro lado. Y tal vez triste en su cama diciendo que podía enseñar esto. Mucha gente no sabe que esto yo lo hago porque hay amigos míos que han vivido esa experiencia, que la están viviendo y en carne propia han vivido alguna de las que le estoy diciendo. Y muchos de mis amigos me dicen, Jaime, ¿por qué tú no buscas un abogado de trust? Julio Pérez me decía, porque queremos aprender de esto. Tenemos una vivienda, no preparamos el trust. Tenemos niños pequeños, o los hijos de nosotros tienen niños pequeños, pero no han hecho un will. No han hecho ¿cómo se llama en español? Un testamento, y se muere la mamá de los nietos, y nosotros tenemos que durar 1 mes y medio sin ver los nietos. ¿Por qué? Porque no hicieron ese testamento, y tú tienes que ir a pelearlo en la ciudad para quedarte con los nietos. Y sin embargo se quedaron, la ciudad se quedó con ellos a veces hasta por 1 año. Porque tú no eres el representante de los niños. La ciudad tiene que hacerse responsable. Y esos nietos tuyos, tú llorando y manejando el trabajo, porque no puede, porque ellos no hicieron, los hijos tuyos, no hicieron un testamento para que esos hijos te pasaran a ti en caso de le pasara algo. Eso mismo pasa con el trust. Tenemos de todo, vivimos una vida, pero ninguno sabemos lo que es trust. Entonces hoy me toca a mí presentarle a ustedes a una abogada que fue enviada por nosotros, por Fran Soto, un gran abogado aquí de New Jersey, para que tengamos la oportunidad de dialogar sobre lo que es un trust, hacernos nosotros los suficientemente inteligentes en esa materia para poder defendernos de lo que nos pueda pasar y que la vida nos salga más suave. So, I will be introducing today Erin Lewis, who, si soy yo cobro bastante porque de verdad no debiera ser gratis. I'm sorry you're doing it for free. But in reality, there are so little, so few lawyers that know about trust that we thank you for really coming, spending your time here with a group of my friends. Most of them are my friends. We've been together for a long time. Some of them been with me for 50 years. And the others have been 20 or so years. So it's a friendship. So feel at home. Feel together with us. Aquellos que no hablan inglés fluently, podemos traducirle simultáneo o podemos hablar con ustedes al final. Así que bienvenidos. Thank you and welcome to be with us.
All right. So we said be comfortable, so I'm going to sit. So this is more like a conversation, okay?
Good.
I believe he had said it is Frank Soto. You don't hear me?
Okay, close.
Closer?
Oh,
Yeah?
now, yeah.
Better? Okay. So first, I'll introduce myself again. Erin Lewis. I have an office in Paramus, New Jersey. I have a second office in Cranford, New Jersey. I began my career at a law firm in Fair Lawn, New Jersey. I became a partner there very quickly, and I went out on my own last year. So I've been on my own at my own offices for about 14 months now. So that's my history. All right, so first I want to touch on a basic estate plan. Usually a plan that consists of a last will and testament, a living will, and a power of attorney will cover most people's needs. When we're talking about trust, we're getting into more complex planning. And it's not going to be for everybody, but that's what we're going to talk about. That's what I was directed to talk about, so that's what we're going to get into. And we can determine if that's going to make sense for you. When you're starting with estate planning with me, what I generally will send out are called my fact finders. It's going to be a lot of questions for you to fill out. From there, I'll be able to recommend a plan that makes sense for you. It's not my job to try to overcharge you or upsell you. I'm not going to tell you you need something that you don't need. It's what makes sense for your fact pattern. If your fact pattern doesn't need a trust, I'm not going to tell you that you need to do a trust. It's also going to depend on what's most important to you, which might be the number one question when we're talking about estate planning. What is most important to you? Is it about leaving something for your children? If you are the breadwinner spouse, is it about making sure your spouse is taken care of if you were to pass away first? Or if you're a single individual, your concern may not be leaving something for anybody else. It all depends on the facts of your case. All right, so a basic estate plan consists, like I said, of those three documents: a last will and testament, a document that directs what happens to your things, your assets, your stuff once you pass away. A living will, the long and short of it is, God forbid you were ever in that situation where you no longer have capacity, generally in a situation where the doctor comes in and says you're brain dead, you have no brain activity. Would you want them to pull the plug or not? That's something that you really should have in writing. Why? Because what happens, God forbid that a parent is in that situation, and maybe it's the second parent, maybe the other parent has passed away already. Usually that's going to open up the door for conflict between the children. Somebody's not going to agree with what the other person says. You want to have it in writing on what you want to happen in that situation. It's basically you speaking when you verbally cannot speak for yourself anymore. A power of attorney, arguably the most important document in an estate plan. Why? A power of attorney is very important in the event you ever become incapacitated. I have a lot of horror stories. One of the horror stories that I have is two spouses. They were in a car accident. The wife was okay, the husband was not. It was like pulling teeth for the spouse to even get information from the hospital, even as the spouse, because they did not have powers of attorneys with each other. The important thing about a power of attorney, in order to name somebody an agent under a power of attorney, is you have to have capacity in order to do it. Once you lose capacity, you can no longer do a power of attorney. The only option from that point on is to do what's called a guardianship. A guardianship is at least 4 times more expensive than a power of attorney, and a lot of complications can happen with that. People can contest guardianships a lot more easily. It's something that becomes public because it's a court proceeding. A power of attorney is something that you do when you have capacity and comes into play to the extent you ever lose capacity and last in the event you lose capacity. So it's in place. In that unfortunate event, life happens to everybody if you ever lose capacity and life happens to you. It's a very, very important document that people don't know about, and sometimes, a lot of times, people overlook. So why is estate planning important for everybody? There's many reasons why people will make estate plans. To have control, to make sure that your assets are going where you want them to go. A big one that is very important is if you have a blended family. I'm talking second marriages. If you have children from a first marriage, new children from a second marriage, if there's room for conflict, maybe your new spouse and your children from the previous marriage don't get along, that can be very, very important when we're talking about estate planning. That's also very important for trust planning, and we'll get into that in more detail as well. There are a whole bunch of different kinds of trust. I won't go through naming them all, but I'm going to touch on a few for this presentation. One thing Mr. Jarvis wanted me to talk about is Medicaid planning. So, 2 big reasons why somebody is going to create an irrevocable trust. Medicaid planning, and I'm talking creditors. When I speak of creditors, I'm always including Medicaid in that group. Medicaid is a creditor. The long and short of Medicaid is you have to be poor, at least on paper, to qualify for Medicaid. The general rule is that you cannot have more than $2,000 in assets in order to qualify for Medicaid. Medicaid is a needs-based program. I do not want people to get Medicaid confused with Medicare. It is not the same thing. Medicaid is a state and federal program. Medicare is a federal program. Medicare is not needs-based, and Medicare generally will not cover long-term care in the event you ever need it. Medicaid will generally cover long-term care, assuming you're able to qualify for Medicaid. The second reason why people will also generally create a trust, if we're talking about tax savings, which may be a concern for some people. So I'm going to touch on those two areas. Right now, the federal estate tax exemption is approximately $14 million. Most people are nowhere near that, and that's per individual. So we're talking $28 million for couples. At the end of 2025, there is a sunset provision. If Congress does not act, the federal estate tax exemption is going down to approximately $7 million with inflation. That's going to be $14 million for couples. A lot of people federal estate taxes still won't be a consideration if you're nowhere near that number if you're talking assets. So you'll hear a lot of people talking about, I have to protect my assets, taxes, 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 and they're nowhere near the exemption amount anyway. So that's something that we would talk about and I would counsel you on if it's a real consideration for you or not. If we're talking Medicaid, this is how the logistics of Medicaid planning for trust work. Medicaid has a 5-year look-back period, meaning for that type of planning to work, you have to have your assets gifted to a trust or an individual, because there are ways to qualify for Medicaid without trust planning. To the extent you really trust somebody, it's the same thing as if you were gifting assets to a trust. You could gift them to an individual. A lot of times where we may see that happen are parents to children, but you do have to trust your children, of course. So, as far as the logistics, you gift your assets to the trust. Medicaid has a 5-year look back. For that type of planning to work, you have to do it within 5 years of the need to apply for Medicaid or the planning does not work. It is a 5 firm year look back for Medicaid planning. A couple of other things that I just want to touch on, a couple of other trusts, and I was just checking my slides here. I don't know, are we on a time limit? Okay, good. All right. Something else that I want to touch on, another type of trust. A lot of times this is a testamentary trust created under a will. It's a credit shelter trust for married individuals. This is a plan where a spouse passes away, the inheritance to the surviving spouse is distributed to a credit shelter trust under the will. That surviving spouse benefits and can use the trust income and the trust principal for their maintenance during their life, and it is a way to shelter the inheritance for estate tax purposes and to defer that for later. So that's one way of at least deferring estate taxes. Another method that people are not, maybe possibly not aware of or may not hear a lot about is an irrevocable life insurance trust. This is a trust where life insurance is either transferred into a trust or a trust is created and it purchases life insurance on the life of the grantor. That life insurance in that trust is shielded for federal estate tax purposes, and the funds in that trust can be used to either pay estate taxes if the estate is subject to estate taxes, and or other expenses after the grantor were to pass away. So that can be a lot of protection, because a lot of times what happens is somebody passes away and there are no liquid funds to pay for anything. When you die, you have expenses that come accruing immediately. So that can be a good way to have liquid funds readily available when somebody passes away. It's often an unused, unknown about method for making sure there are funds readily available for those expenses that come up. I can tell you, as far as estate taxes, if your estate would be subject to inheritance taxes, there are firm deadlines to make those payments that the state does not care about what's going on. If you didn't plan and you don't have the money to make those payments timely, interest and penalties accrue daily on the tax that is owed when life happens and that stuff happens. So that is a good one, the irrevocable life insurance trust. One thing Mr. Jarvis and I were talking about, and this can be a very good mechanism, again, something unknown about and often underutilized, and that is long-term care insurance. Long-term care insurance is like any other insurance. If you get it when you're younger, that's when it's more affordable. After a certain age, it may not be realistic that it's something that you can afford, but it's something that you should ask about to see if it makes sense. Long-term care insurance will be used oftentimes as a replacement for Medicaid. It's insurance to cover long-term care later in life. Like I said, any other insurance, similar. If you get it when you're younger, it's more affordable at that time. So it's something to definitely talk to an advisor about. See if it's something that can fit in your budget. See if it's something that makes sense. And again, it's something that a lot of people don't know about, but can be great for later. I have those clients that have long-term care insurance, and Medicaid's not really a concern for them later. There are also mechanisms for temporarily getting long-term care insurance to bridge that 5-year gap in the process of trying to qualify for Medicaid. So there's a lot of different things that can happen, because the 5-year look back oftentimes becomes an issue for people. Let's say you have assets that can cover for 3 years, and maybe can you afford long-term care temporarily for that 2 years to bridge that 5-year gap? That may be a possibility depending on your fact pattern. So that's something that's very, very important, the long-term care insurance that, again, a lot of people don't know about, and oftentimes if you do know about it, you don't utilize it. I'll go over the 2 main different trusts. When you make a trust during life, it's called an inter vivos trust, meaning it's living. It's a living trust. When you create a trust under your will that's funded after you pass away, it is called a testamentary trust. If you have a trust under a will, that is the general term for the trust, a testamentary trust. What I can tell you about all your estate planning documents, your will, your living will, your power of attorney, and any trust that you make while you're alive. So long as you have capacity, they can always be amended. They are your documents, they're living trusts, meaning they grow with you. Now, when we're getting into irrevocable trusts that really offer the Medicaid protection, the protection against other creditors, estate taxes, that's something different. Generally, it's like the term says, irrevocable, but are there ways for us to undo them? Yes. That's why when we're having those conversations about irrevocable trust and Medicaid planning trust and protecting assets from creditors, you have to understand the type of planning because it is a big jump. A lot of times when you're talking about an irrevocable trust, one thing you're giving up is control. So you have to think about that. You're thinking, I've worked my whole life for everything that I have, and now I'm gifting it away to a trust that I can no longer control. That can be a big, something very major that people can't quite wrap their head around. And a lot of times we'll get into the deep discussion about what that really means, and then people decide they don't want to do it. Now, like I said, there may be other mechanisms that may be suitable for your fact pattern. So it all depends on what makes sense for you. I think that with the internet and people kind of getting in and doing their own research, they hear trust and everybody thinks that they need a trust, and that just may not make sense for you, and that's okay. One thing too, a consideration when we're talking about Medicaid planning, it's like a comparison. You have to compare possible tax implications to the actual expense of a long-term care facility or having somebody come into your home to take care of you on a long-term basis. If you're of a certain age, maybe the expected lifespan is, I don't know, depending on the fact pattern, we're probably not looking at Medicaid planning. It may be too late at that point. There are those people that come to me where they need long-term care and they're already looking at facilities. They come to me and they say, well, how do I protect my house? It's too late at that point. We can't do that planning anymore. Medicaid has the 5-year look back. You will spark the penalty period and you will not qualify. I also have those clients where they come to me, it's a bit late, but they say, let's try. And they don't live out the plan. They die within that 5-year period before it even makes sense. When you're talking about doing this type of planning, you have to do it at the right time, or simply it's going to be too late. There's not going to be anything that I can do or any other estate planning attorney can do for you. Just one other thing I do want to just re-highlight, and then I'll give it back to Mr. Jarvis, is as far as my horror stories, when I'm talking about when people pass away and they don't have these documents in place, I just want to re-highlight that when we're talking about blended families, second marriages, the door is always open for confusion and disagreements. Just as much as with the estate planning, I handle estate administration when somebody passes away. This is how I classify my practices. When we're talking estate planning, at that point, I am doing my best to be proactive to avoid the problem. When you don't do the planning and you pass away and life happens and nobody knows when it's going to happen, that's when I'm practicing reactively. I'm probably trying to fix a problem because you didn't do what you were supposed to while you had the opportunity to do it. So if it's something you're even thinking about, protecting a house, my second marriage, hey, I want to make sure that my assets are left to protect my spouse, but then when the dust settles, I want them to go, what I have left to go to my kids. Maybe you don't want it to go to your stepkids, whatever the case may be. Get it in writing. That's what I can say about it, because if it's not in writing, the door is open for there to be a disagreement and an issue later.
We talked about the different kind of trust, right? But I never heard you mentioning the executioner, administrator, and so on, or whatever,
The terms.
what is the capacity of each one within the trust? For example, administrator, if you have to name or an administrator to your trust, what its capacity for that person, what they can do and what they can't do when you pass away.
Gotcha.
Another question. I give you a few questions.
I need the wine. Let me drink the wine.
Yeah. Let's cheers. Now, estate planning only covers the United States. Can we include property in other countries? For example, most of us are from the Dominican Republic. Can we include properties from the Dominican Republic in a trust here? Come on, man, you're here. You can hear me? That's it. That's about it.
That's all.
That's all. For now.